Haber and Martinez. As you may be able to see, Martinez is not here, but I am joined by David Marcus, who is off to my right, maybe your left, depending upon how you're looking at things. And he has kindly agreed to join us for today's episode of AYS number 69. I've entitled today's episode, Federal Criminal Defense Practice, White Collar, and Then Some. We don't talk a lot about federal work because I don't do a whole lot of federal work. But David, on the other hand, does mostly federal work. He's not relegated to it. He does grace us in state court every now and then, make us realize how little and silly we really all are. But David, in all seriousness, is a good friend and an incredible attorney. He is a graduate of Harvard Law, although he started at UM. He's a former federal public defender, and he's been in private practice for quite a while now. I guess, when did you start your private practice, David?
I started private practice in 2002 when I left the public defender's office.
So you're in 21 years basically doing your own thing, and before that taking marching orders from the good side of the federal government, right?
That's right. Absolutely.
The feds have that good side, dark side thing going, the federal PD versus the U.S. Attorney's Office.
You bet.
So after that, David went to work. He had a partnership with Milt Hirsch for a while. Milt is now a circuit court judge. And when David was sharing office space with Milton, I was in that suite as well. So I had the benefit of spending time and shooting the breeze and learning quite a bit from David during that time period. He may be my junior in terms of years on the earth, but I certainly look up to him as a practitioner, and I thank him again very much for his time in coming here today. So, Dave, thank you again. It's good to see you.
Good to see you. Thanks for having me on.
Thank you for coming on. I want the folks to know before we get started, I call this a podcast, but it's not really a podcast. This is kind of like a de facto podcast. But you have an actual podcast called For the Defense, right?
You bet. I interview criminal defense lawyers like you, and we talk about great big cases. It's a lot of fun.
Well, I'll take that plug, although I would say that the lawyers that you're interviewing and speaking with on your podcast maybe are not quite like me. Although, you know, I could certainly see myself at a dinner party with F. Lee Bailey, Alan Dershowitz, Bruce Rogo, maybe serving them cocktails.
Yeah.
But you know, interestingly, I was looking through your podcast website, which for the folks, you can find David's podcast anywhere that you get your podcast. But I believe it's also forthedefense.com. Is that correct?
Forthedefensepodcast.com. Yeah.
Forthedefensepodcast.com. So anybody who's interested, David's podcast, as is his practice, is a little bit different than this one. I would call it a little more serious, although I like to think that we do a good job for what we do here. And it's funny, one of the things I wanted to say up front was I was noticing on your bio, on the bottom of your page, it says, David is committed to zealously representing each and every one of his clients. He's built a reputation for winning the most difficult cases with creative strategies. He takes each case personally and does not like to lose. And I couldn't help but think how similar that is to my own, which is Haber PA or hashtag Haber PA, providing boutique, creative, effective, and zealous criminal defense advocacy where it's all about reasonable doubt. And so it's kind of like an interesting juxtaposition, right? Because we're going to talk a lot about the differences between federal and state court, but you handle, I would say, much more complex, much longer, more intense cases as a general rule than the type of stuff that I do in my daily routine. So maybe you could tell the folks a little bit what it's like to be a federal criminal defense litigator.
Sure. So, you know, I started out, you know, doing any case that somebody would hire me. When I left the federal defenders, if somebody had a couple grand, I would do their case. So I did, you know, one-day gun cases and one-day drug cases when I started. Don't do a lot of that anymore. Most of my practice now is sort of like you say, the larger white collar cases. But in a lot of ways, Michael, they're similar in that the government makes their cases on snitches. They make their cases with cops, just different kinds of cops. So a lot of the trial work is impeaching witnesses, impeaching the detectives, or in this case, the FBI agents, impeaching the snitches, the cooperating informants, people who are making deals with the government. They just go on for longer. There's a lot more paper involved, a lot more emails, documents, financial records, that kind of thing. But at the end of the day, the trials are similar, just longer, in that you're trying to discredit their case.
So the similarities I get, but it is a little bit different because the vast majority of state court work is impromptu arrests, right? I mean, somebody gets pulled over for speeding or for having a defective taillight, and it turns into a possession case or a firearms case. These are not investigative protocols, whereas I would say the exact opposite applies in your world. Most of your cases are the product of intense, long, detailed investigative practice and policy, sometimes with multiple agencies, the FBI, the DEA, Homeland Security, SEC, whoever. I mean, you've got pools and teams putting together cases sometimes for years before they ultimately make that arrest, whereas most of what I do, again, it's in the moment.
No, that's fair. I agree. Those are reactive cases where the police arrest on the spot and react. Whereas you're right, the federal cases are much more proactive and investigative for years. And a lot of my practice, I have to say, is representing those folks during that investigative stage, which doesn't happen all that much in the non-federal, non-white collar world, where you have the benefit of getting to know your client in the case before there's an indictment. And as you say, that can go on for many years. And a lot of the work is trying to convince the government that they don't have a case. Once a case is brought, of course, that's a different story. But yeah, there is a lot of that. That's true.
I would assume that you can engage in, I hate to cross over to the medical field, but a little preventative medicine during that time period, right? Because at the same time as you're chipping away at the government and doing whatever it is you're trying to do to work off the line, you can have your clients doing things proactively to try and develop some form of mitigation during that time and making it a little meaningful, correct?
Either mitigation, if you're looking to work something out, for sure, or preparing the defense. The government is trying to accumulate all the emails, financial records, those kinds of things, and you can do a parallel investigation where you're going through those emails, you're going through those records, and providing to the government what you believe are helpful, and showing that there's not a crime. There's big strategic decisions to make, because the only advantage you really have in federal court at a trial is that they don't know what's happening, right? They're not entitled to a lot of discovery. They're not entitled to depose your witnesses like in state court. So surprise at trial is one of the big things that a defense lawyer has going for him. The question is, so do you disclose the defense during the investigative stage? Do you reveal the good emails? Do you reveal all that good stuff in an attempt to try to convince them not to prosecute? It's always a tough decision.
Yeah, I would say, you have some clients who can't shut up. We could consider our former president who, just gave an interview, and I have to assume that his lawyers are rolling their eyeballs in their head because, it's one of the things that we fear the most are statements from our client, especially a client who thinks that he's smarter than he is.
I wonder if they're rolling their eyes. I'm not so sure, because I know a lot of folks have said that, but Trump's going to be Trump, and that's why he has 50% of the vote and 50% of potential jurors by being himself. And I think one of the, we have to be careful as a lawyer to try to make your client into somebody he's not. In this case, of course, there's danger with him speaking, and there's no question about it. But jurors are watching, so they may like that. The jurors who are going to be pro-Trump are going to see him out there calling this a witch hunt and so on. And they may like it.
Yeah, I suppose that's true. I guess it all boils down to spin one way or another, right?
Right, exactly.
So I was thinking more along the lines of, like, in my cases, a lot of time I'll get a case, whatever it happens to be, and I'll know that it's not a trial case right out of the gate for any of a variety of reasons. And so I may have my client or instruct my client or encourage my client to take certain proactive measures that will assist me later on in terms of mitigation, whether it's negotiating with the state attorney or if I have to deal with the judge directly, right? So I'm thinking like sometimes I'll have them get into therapy or I'll put them in a rehabilitation program or things like that. So that's, do you ever have any occasion to kind of steer the client in a personal / professional way during that pre-indictment or pre-criminal complaint process?
Sure. So we've had cases where financial cases where you want to make restitution, for example, during that stage, or like you say, get therapy. I think there's the best therapist in town has the last name Haber. So Mary's the best, and your mom we use a lot. So yes, there are great things you can do to sort of mitigate if that's the goal. If the client comes to you and says, "Look, we need to do everything we can to work this out," absolutely. Then you're in a different phase. My practice, for better or for worse, is typically people coming to me wanting to fight it out and go to trial. So my practice does less of that than others, but we definitely do it when you need to.
I could certainly see that. I mean, we get that a lot in my practice as well. I get a lot of cases from other lawyers, not from lawyers directly. I mean, other clients who have been represented by other attorneys who discharge that lawyer and come to me because a plea was being crammed down their throat. They were sold a bill of goods by somebody. Oh, you've got the greatest case in the world. We're going to walk you on this. You're going to be righteous. There's going to be a ticker tape parade, yada, yada, yada. And then 6-8 months down the road, this person's out, $20,000, $30,000, and the lawyer's trying to cram a plea down their throat, and all they ever hear is motion for continuance.
Right.
Whereas our mantra is speedy trial, speedy trial, speedy trial. Look, and sometimes that doesn't work either. Obviously you can't have that attitude on every case across the board. But there's another significant difference between state and federal court, right? I mean, you can kick state courts down, kick most state court cases down the road pretty much as long as either side wants to, unless a speedy bomb is dropped by the defense. Federal court, everything's kind of fast tracked, isn't it?
Yeah, it's true. Things go a lot faster in federal court. Now, in a lot of these bigger cases, you can get time. And actually, you mentioned Trump before. That's the big debate in Trump is when is that trial going to go? It's a really complicated, classified document case. The government just filed a motion to continue it till December. It won't go in December. It'll go later than that. Typically a complicated case like that, it will take about a year to get to trial, I would think. And that's, most of my cases from the time of indictment to trial, it could be a year or more. But you can go much faster if you want to. And there are lots of judges who are on the rocket docket, both here in this district and in other districts who are going to force you to trial pretty quick.
Now it's funny. We, every now and then in state court, as you know, every now and then we will get a judge elected, more likely appointed, who's a former federal prosecutor. And they come in with that rocket docket mentality in state court. Everything's a 3-week reset and then we're ready for trial and there's no more continuances. And it takes those judges a little while to acclimate to the reality of the state court system versus the federal court system.
But I imagine in those cases where the judge is pushing folks that there's some pretty good plea offers made.
Sometimes yes, sometimes no. I can remember one judge who I'll go unnamed at the moment who refused to take negotiated pleas.
Okay.
He refused to accept pleas sitting on the bench saying, no, that doesn't sound reasonable to me. I'm not going to accept that. And, now you've got prosecutors and defense lawyers rolling their eyes because, this judge is just not dialed into the realities of the system.
Just absurd. That's one thing that's always bugged me is judges who won't agree to take negotiated deals. I mean, this is supposed to be an adversary system, right? If the prosecutor and the defense lawyer have resolved it, the judge should take the deal. The judge is supposed to be a check on the government, not a check on the defense. So the only time to me that a judge should reject the deal is if it's too high, not if it's too low.
Well, you never know. Some, judges are people too. I always have to unfortunately say that. But, we always tell our clients, the prosecutor's not your buddy, okay? They're not here to help you. That's the reality. They're here to prosecute you. And maybe, if you're lucky, you will come across a prosecutor who actually takes their job as being a minister of justice to heart and will treat you fairly. But don't expect that in state court. But we also tell our clients that we have to fight the judge very often. The judge is an adversary, not a neutral and detached magistrate.
Right. We had a trial recently where my partner Margot Moss said the judge was the best prosecutor in the courtroom, and it's true.
And you have to be real careful, right? Because we do a very delicate dance around judges. We have to stand up to them as an advocate, but there's a line that you can't cross. Otherwise, you're going back into custody with your client.
Yeah. No, that's true. And that there's always that fine line with judges and standing up for your client and fighting as hard as you can without crossing the line. It's tricky.
It reminds me of the scene in My Cousin Vinny when he first gets held in contempt and he's so happy the second time because he says, "I'll finally get a good night's sleep."
That's great. That's great. That's great. It's fun. We you mentioned the podcast. I have Abby Hoffman's lawyer Jerry Lefcourt on the show next week, and he talks about getting held in contempt in that case in the Chicago 8 trial back in the 60s. And he gets put into jail on a Friday afternoon, and his colleagues come and they say, "Listen, we couldn't bail you out. We'll see you on Monday." And the Seventh Circuit on its own read about it in the newspaper and cut him loose that evening.
That's fun. Well, it's again, you have different types of judges and of course different personalities with the lawyers, right? I mean, I had a judge who came to bat for me where a prosecutor, came after me personally in a courtroom, and the judge said, no. We're not doing anything with lawyers in this courtroom. If you want to do something with Mr. Haber, you get Ms. Rundle in my courtroom in person, and she can explain it to me.
Right.
And of course, it fizzled out right away.
Right. I mean, it must be interesting for you now, Michael, because most of the judges are in their 30s, so much younger than us, right? And you're starting to see that a little bit in federal court, but not as much. In state court, I mean, there are a lot of really young judges who have very little life experience to be doing to be judging. I imagine that's got to be tricky.
It definitely turns into a circus in some situations, and again, a delicate dance. Human nature, especially, right? What's the line? Power corrupts. Absolute power corrupts absolutely.
Yes, sir.
And we have a term for it, right? Robitis.
Yep.
There are many wonderful judges who take that robe and just never lose sight of who they are and where they come from, right? The Stan Blakes of the world. There are just some really fabulous judges out there. And then there are others who, get that robe and it's like Dr. Jekyll and Mr. Hyde. They turn into a completely different animal. People that you knew for 20 years sometimes, and you would call your friend, and the next thing you know, they're just absolutely abusive on the bench.
It also happens when a state court judge, some of them are wonderful in state court and then get moved over to federal court and become, when you get that lifetime appointment, talk about robitis. It's robitis for life. That's, I always wonder what's a better system, the appointment system or the election system. There's pluses and minuses to both. The one good thing I think about the election system is they have to face the voters again. So they can't be too much of a jerk. Or the lawyers will revolt. In federal court, you don't have that check.
Well, I guess counterpoint would be nobody votes. I shouldn't say nobody, but the public turnout for judicial elections is extremely low. Most of the public doesn't know or care. Especially when you get on to should we retain this appellate court judge? Should we retain this Supreme Court judge? Nobody knows who they are unless you're a lawyer, and even a lot of the lawyers don't know who they are. So it really becomes not so much a truly valid voice of the electorate as opposed to who had more money in their war chest, who had more billboards up, who's got more friends in the community that can spread the word. It reminds me more of Chicago in the 20s than it should.
No, I agree with all of that. The only thing I would say is they still have to raise money, as you say. So they have to go to the lawyers in town and have these fundraisers. And I guess if they're total jerks, I mean, you would know this more than I would, but they would have maybe trouble raising money or getting a fundraiser or something like that.
One would think, unfortunately.
Right.
It is what it is, right?
Yeah. So, no, right. I guess.
I'm sorry.
No, the only worst thing is for the judges to have these lifetime appointments where they don't have to answer to anybody, and then forget about it.
Yeah, they don't get impeached too often, do they?
No. There was a famous one of Alcee Hastings down here. But then, of course, he was one of the good guys, and he still got impeached. And then he was at least able to run for Congress.
You know, you brought up an interesting point, and here in state court, we see this a lot, where we get a new judge that comes in, whether they're young or old, it doesn't always matter. Although younger ones tend to be more have come with innately more problems. But you get new judges that have never practiced, and all of a sudden you get somebody who's been in the civil world, and they get appointed sent to the criminal bench on day one, and they don't know the first thing about criminal law or criminal procedure. And as I guess for the benefit of the folks, just real briefly, in local state court here in our circuit, anyhow, I suppose it works same everywhere, but here in our circuit, we have different divisions of the court system. There's a criminal division, both circuit and county. There's a civil division, both circuit and county. There's family, there's probate. You know, we have a bunch of different areas, but in federal court, they're just a judge, right? And they do it all. So your same judge that's trying a white collar criminal case or a drug trafficking case or a bank robbery case is also handling federal contracts cases and other types of civil litigation issues.
It's true. Although, listen, what we do is not rocket science. So to me, listen, in the old days, right, lawyers were generalists. My dad was a generalist. He did practice all kinds of law. Now the law has become so specialized. Not only are you a criminal lawyer, well, you're a federal criminal lawyer, you're a state criminal lawyer. Not only are you an IP lawyer, but you're a specific trademark lawyer. I think that's actually bad. I think the old days where, lawyers were more generalists, just like our judges, was probably the better practice. I think things are too specialized now. And I think, this is not rocket science. Lawyering, one of the things I love about my job is that I learn all these different businesses and areas. We're not building rockets.
Well, but we are responsible in our particular genre for people's lives, which is at least as important as building a rocket. I mean, it's certainly to that person or their family. I always say one man's misdemeanor is another man's murder.
No, I agree for sure. I agree with you on that. And everybody who walks through your door, it's their most important time in their life. It's their most important case. It's to them, as it should be. It's literally the most important thing. I guess my point was it's not to learn the law in that area is not all that hard. In other words, if I was going to come into state court, I've never done I don't know, pick a state court crime. I think I could figure out the elements and how to do it. And I think the same for you coming into federal court. If you were going to do a criminal antitrust case, it's not like it would take you that long to figure out how to do it.
First, I figure out how to spell it.
Fair enough.
Well, it is a different genre. And I tend to think that federal, whether it's, I agree with you in terms of if you can graduate law school and you can get a law degree and you can figure your way around a courtroom and you can distinguish between a prosecutor, a judge, a bailiff, and a clerk, you can probably handle pretty much anything anywhere if you put in a little bit of brain power to try and figure it out. But that said, our cases are radically different. So let's kind of talk about some of those just generic types of differences, right? Because I mean, my average case, whatever it may be, if it's a trial at all, it's 2 days, 3 days, 4 days. I mean, my longest trial in state court was 8 days. That's the longest trial in 31 and a half years. So, and 8 days for you is like preparing for cross-examination. I mean, it's, your trials last months on occasion.
Yeah, no, that's true. I will say, I'm more nervous when I go into county court to handle a misdemeanor than when I'm in federal court, just because it's what I'm used to, right? Same for any lawyer, I guess. Like I'm used to how it is in federal court. I'm used to sort of the procedures. When I go into county court, I don't know how to get my case called up. I got to figure out who it is to talk to, what the forms, all that stuff that comes along with it. So there's always going to be that level of anxiety when you're doing something that you're not used to. You're right. I mean, the cases in federal court tend to last longer. Margo and I just tried Andrew Gillum's case up in Tallahassee. The trial was about 2.5 weeks. And before that, we were in New York for a 5-week trial. So they do last long.
let me ask you this, just as a general lifestyle question. Um, I mean, you're married, you have two beautiful daughters, right?
Three.
Three beautiful daughters. Um, it's a lot to juggle. You have your practice, you have your home, you have your kids, you have your, situations going on there, and next thing you know, you got to be in New York for 5 weeks.
Yeah.
How do you practically juggle that? I mean, how do you wrap your brain around dealing with that? How do you focus on what you need to focus on without being distracted about, you know, wanting to be with your family, wanting to see your family, needing to deal with putting out a fire at the office? It's the mechanics of even doing that are so mind boggling to me.
The travel is hard. In the last couple of years, the travel for trials has been crazy. Usually we would only do, one out of town trial a year or something like this. The last couple of years has been nuts. But, Milt Hirsch used to say, there's two types of criminal law practice. There's the one that makes shirts sort of, on the machine, and they can make a million shirts, a month or whatever it is and sell them. We make shirts by hand, Milton used to say. So you can only make a certain amount and they cost a lot more. So it's a lower volume, and that's one way you deal with it, because you just deal with a much lower volume of cases. I don't know how some of you and your colleagues handle the number of state court cases you do. My mind would explode if I had that many files.
It's funny because I do the same. I maintain that balance, right? I make my custom shirts, but I make more than maybe the next guy next to me. So, I'm working a little bit harder, but I'm doing the same type of boutique practice as you are, where I'm picking and choosing. And I recognize that I can only stretch myself so thin, because what'll happen is, in a moment where a client needs me, I won't be there because I'll have too much on my plate. And that's really just a function of time and experience, right? You bite off more than you can chew, and you realize what you did wrong, and you don't make the same mistake again if you've got half sense about you.
It reminds me of that ad where they're showing, like, this company starts on the internet and they see their first sale and they all cheer, and then they see the sales start to pick up, and all of a sudden they're selling too many, and they look at each other like, what do we do now? Because they've sold too many. You have to be careful. My practice is 6 lawyers now, and the question is always, do we grow bigger? Do we stay the same size? And it's always a tricky question, because you want to be able to devote the normal attention you can to each case.
So are you able to, I mean, I know you're able to because you do it, but is it taxing on you to be away and to have to deal with those types of really serious cases out of town? And again, being away from your family and your office, those calls are still coming in. I mean, people are still trying to reach you. You still have to field, issues that are on the plate every day.
Yeah, it is very difficult. Like, the family stuff, being away from the kids is horrible. My oldest is in college now, so it's easier with that, but I still have 2 at home. That said, I prefer trying a case out of town than here. Why? Because when I'm out of town, everybody else is going to have to deal, because I can just focus on that one trial. I'm not dealing with home. I'm not dealing with all the calls at the office. I'm not dealing with all the judges. They know I'm in trial. They know I'm out of town. I go back to the hotel. I just work. So I prefer a trial out of town. It lets me focus. You come back and there's a zillion headaches with the office, and you try to catch up with family and try to regroup. But in terms of just the trial itself, I prefer out of town.
So I very rarely leave the Tri-County area. When I do, on occasion, I always bring in local counsel. It's one of my practices. Not everybody does it. And I suppose it may be different in federal versus state practice, but I, usually adopt the philosophy that if I get called out to, let's say, Pensacola to handle a case, that Pensacola judge, the first thing he sees when I walk in that courtroom is, who's this, idiot from Miami? Why is this guy bringing someone in from Miami into my courtroom up here? This guy doesn't contribute to my campaign. This guy didn't put any money in my account. He doesn't vote for me. So I like to have somebody in the courtroom that does contribute to the judge's campaign. Somebody whose face the judge does recognize. And that way I tend to feel like it gives me a little more credibility with the judge and a little more respect to say, look, Your Honor, there may be some peculiar local rules that I'm not aware of. There may be some customs or protocols that need to be, appreciated that I don't know about. That's why I've got Jimbo here to help me out.
Yeah. You know, I've done it both ways, Michael. Sometimes we have local counsel, sometimes we don't. There is a benefit, again, to being that out of town lawyer that doesn't have to see the judge at the bar or see the judge in the community or be in that courtroom again. You really don't have to worry about the next case. You can really worry only about this case and not worry about how the judge is going to view you later on. In that case that I was talking, the Andrew Gillum case, Margot and I did not have local counsel. We just did it on our own up there. And we butted heads with the judge. I will tell you, it was a big fight every day with him. We've had cases in Kentucky where we didn't have local lawyers, but there's again, pluses and minuses to it.
So when I'm assuming you're a member of the Northern District of Florida?
We became members for this case.
Oh, we're not a member prior to that.
Correct.
So
Correct.
Just so the folks understand, state court and federal court are different entities. And there is some overlap, and we'll talk about that. But there are separate systems. They have separate rules. They are separate sovereigns. They have separate everything. And each state has its own separate laws and rules, right? We've got 50 states, and each of those states has their own protocols, their own systems, their own procedures. And within the state, there are smaller jurisdictions. Here in Florida, we have 20 different judicial circuits, each of which are sentient. They're all bound by state law, the same law, but they have different operating rules. We call them local rules. In Florida, of course, the federal government is one system, but every state has its own individual federal district, and many states have multiple federal districts in a single state. So here in Florida, there's the northern, the central, and the southern federal districts, correct?
Correct. So there's 3 different districts here in Florida, and like you say, each one is very unique with its own set of rules. One thing that we in the Northern District of Florida, when we were picking the jury in that case, the judge told us we could do no social media research on the jurors. That was his practice. Really puts a limit on what you can find out about the jurors. We were used to doing lots of social media research on the jurors. It turns out that one of the jurors who held out for conviction, it was 10-2 for acquittal on some of the counts, had on her Facebook page, "Trump is still my president." Now, for an Andrew Gillum case, we would not have kept that juror, but we weren't able to find out because no social media research during jury selection, which I thought was ridiculous.
So here in state court, the prosecutors dig through, and in state court we're talking about, they dig through social media. They've got everything.
You should be able to. You should be able to look at jurors' social media. You should be able to know what makes them tick and what they're saying. Why not?
Well, and I agree. And a lot of times what we find are jurors are again, people like anyone else. And some of them are not as well-intentioned as others. There are some jurors who have their own agendas. There are some jurors who want to make a statement. There are some jurors who have a stake in the case. And it would be nice in a perfect world to be able to count on them to tell the truth during jury selection. But we know that doesn't happen too. I'm sure you've had it happen to you in your career. I certainly have, where you find out in the middle of a trial that a juror has a conviction and never disclosed it.
Or worse, look at what happened in the Ghislaine Maxwell trial. And famously, one of the jurors afterwards said they did not tell the truth during jury selection about being the victim of sexual abuse as a kid. That's what the whole case was about for Ghislaine Maxwell. She moved for a new trial. She should have gotten it. She had this stealth juror on who did not give up the background. No defense lawyer would have let that juror stay on had he told the truth. Funny, I just got called into state court 2 weeks ago for jury service. So I was waiting in the jury room. What's that?
Civil or criminal?
Criminal at the Justice Building, and I got called up to do some voir dire in a courtroom, and the case settled as I got called up, so I was released around lunchtime. I was hoping I was going to get a chance to serve.
Yeah, that'll be the day.
I don't know.
Let's just touch real briefly on a issue that doesn't happen all that often, but I find it fascinating, and there's a couple dovetails that do happen with better frequency. You've got individuals every now and then that are concurrently charged with the same offense in state and federal court. Some crimes violate both state law and federal law, and there's no double jeopardy issue. They're separate sovereigns. So, for example, if you have a bank robbery or certain drug trafficking cases or firearms cases, they could be state, or child pornography, I would suppose, could be state or federal charges. Have you ever had occasion to be involved in a dual prosecution for the same conduct, concurrent?
I've never represented somebody in both state and federal court for the same offense, but I have represented somebody in federal court where they had been charged in state court, where they had been acquitted in state court and then brought over to federal court. A bunch of different scenarios like that. To me, it's just outrageous. I think you should get one shot. This idea that there are dual sovereigns, but really it's, Metro-Dade police investigates and arrests, let's say, for a gun charge. If that person's brought, in state court first, and then the FBI decides to pull it over to federal court, why should they be able to do that? So a person doesn't have the ability or resources to defend on two fronts. And to me, it's just not right.
And it does happen, though. I mean, not with
All the time.
frequency, but what you see more often, and what we do see more often, is where you have somebody who's got separate cases, but proceedings in both arenas, right? And then you have the issue of cooperation and coordination. And that I have been involved in on multiple occasions, where I have somebody who's got a state court sentence that now has to deal with a federal court issue. Let's say that they picked up a state court case. They were on federal probation at the time. They get prosecuted in state court for the new case, and now they have to deal with the federal probation violation, which technically is a completely separate matter and a completely separate sentence. So, Go ahead.
No, I was just going to say, it's just, it's not right to try to jam people up in two different places for the same thing, in my opinion. If somebody commits a crime and they get charged in state court, the state court can handle it. Same in federal court. You shouldn't be able to jam them up in state court and then jam them up for their federal probation violation. I mean, it just seems like piling on.
But it happens with great regularity.
Oh, all the time. It's common. It's a common occurrence.
And so my question to you would be, how amenable is the federal judiciary, in your experience, to show the type of disinterest or compassion that you're showing with regards to, look, you know what, guy's paying his pound of flesh over in state court. I don't need to take anything more of him.
Compassion from a federal judge, Michael? I don't know what you're talking. I don't know what world you're living in.
Yeah, the mighty M's, right?
Come on. There are some of the old timers who have a real sense of justice. Judge Moreno, some of those guys who really try to figure out what the right sentence is, as opposed to just looking at the guideline book and saying, there's 16 points here. That's 32 months. So ordered. To me, that's crazy. But the old timers are really good with trying to give out some fairness.
My experience has not been good in terms of federal probation violations.
It's terrible. It's you don't get a lot of compassion over here.
And speaking back about the judges, I've had many, not many, but the times that I've done it, I've negotiated agreements with the assistant United States attorney that the judges flat out rejected.
Yeah. So, we talked about this earlier. To me, I don't understand how a judge rejects a deal struck by the parties who know the case. This is an adversary system where, if there's a resolution, what's the case in controversy to adjudicate? It's been resolved. Here's the resolution, judge. In a civil case, you wouldn't see it. Civil lawyers file their notice of settlement. It's over. The judge doesn't get involved in that.
Well, but that's a different protocol, right? I mean, in civil, the parties own the case. I suppose the same could be said in criminal if you look at the U.S. attorney as the party being on behalf of the people of the United States. But I find in criminal court, it is different because we get a lot of cross stuff, civil, criminal in state court. Great example would be somebody gets arrested for misdemeanor domestic battery, and the alleged victim goes and gets a civil restraining order against the respondent/defendant. So there's dual cases going on at the same time based off the same conduct. Well, that plaintiff in civil court owns that injunction case. And if he or she decides at some later time, I don't need this, I don't want it, forget it, it's done. The judge has no power to say anything. Whereas
it should be the same way in criminal court. There's a separation of powers. If the executive branch brings a case and then says, we're going to dismiss a case, why should they have to file a motion and get approval from the judge? You saw that in the Michael Flynn case, but they do. If the executive branch who brings the case says, we believe the appropriate resolution is a year, and the defense lawyer agrees and there's an agreement, why should the judge say, I think it should be 2 years? It shouldn't happen. But you're right. Criminal cases are treated differently than civil cases. To me, it's absurd that they are.
I find it insane as well, but it is. I want to ask you a question about fees, because everything I do, virtually everything, 99% of my cases are flat fee cases. Client comes to me, I read a police report, I interview the client, I get an idea of what it is that we're looking at. I try and figure out a litigation objective, both primary and secondary, sometimes even tertiary, how much time and effort I need to put in the case to get the client to where I want them to be and to reach the resolution that we were looking to reach. And I charge X, whatever number I come up with. Usually I'm pretty good. I mean, every now and then I work quicker and earn a little more if I break it down per hour. Every now and then it's the other way where I wind up having to put in more effort. But, overall it works out. I'm pretty good at quoting those fees. I very rarely do anything on an hourly, although every now and then I do. How does it work in your arena?
I have both. I'd say it's 50-50 with flat fees and hourly. In those cases that we talked about where it's an investigation pre-indictment where we're working, most clients feel more comfortable doing that sort of work on an hourly. And because of the nature of my work, a lot of times I'll represent a target who works at a company, and the company will say, we'll pay the fees, but they don't understand paying flat fees because they're used to paying civil lawyers by the hour. So they want to pay the criminal lawyer by the hour as well. So I do a lot of by the hour work now, and that's in the white collar world pretty common. But for cases that go to trial, you can feel uncomfortable doing it by the hour, because if 2 months before trial the company says, you know what, we're not paying anymore, then you're stuck. So you have to make sure you have enough in your trust account to cover the trial, and it could get dicey.
So what I do in those circumstances is I bifurcate my fees, right? I'll charge a flat pre-trial fee, and then in the event that the case goes to trial, I do it on a per diem. So they basically pay for every day or a portion of a day that we're in trial, a separate fee if the case goes to trial.
We do that as well. There's all different ways to do it. If you're doing flat fee, that's one way to do it. If you're doing an hourly, you can say it's an hourly up until trial, and then it's, by the week or by the day, whatever. But there's lots of different ways to split it up. More and more of my clients like hourly because they want to see, the bill and what work's been done every month. And I have to say, my experience has been that my flat fees underquote how many hours I put in. So if I quote, if I charge a flat fee, I'm just making up a number, $25,000, and I keep track of my hours, invariably I'll charge more than 25 grand.
Yeah, I can empathize with that. That's like the story of my life.
Yeah.
But then again, it's a different arena, right? Because in my arena, let's just take your typical DUI case. If you charge by the hour for DUI, you better have an extremely wealthy client. Or you better just be the tippy tip of the iceberg and the best lawyer in town, because there are just too many lawyers that charge very, let's just call them unreasonably low flat fees. And it's very difficult to compete with that as a practical matter.
Yeah, I imagine that's really hard. And there's so many lawyers out there now, the competition's fierce. So the flat fees for those cases get pretty low, but a lot of times people get what they pay for. If they're going to pay $1,000 or $2,000 for a lawyer, they have to realize they're not going to get that handmade shirt that we talked about.
Of course, but that's unfortunate market realities, right? It's just the way of the world.
Yeah. No, it's true. It's true.
Another one of Milt Hirsch's sayings was that people have to be able to afford substantial justice.
100%.
Substantial justice can be cheap, but substantial justice is not.
That's right. We all agree.
So let's let's talk a little bit about. You mentioned snitches earlier. I'm assuming that you're as big a fan of the late great Al Krieger as I am.
The best.
Was there any better cross-examiner of snitches than Al Krieger?
I saw Albert. I was lucky to see him. There's nobody like him. Nobody can replicate that. I've watched lots of lawyers, and you sit in the background and back of the room, and a lot of times you say, I could do a better cross than that, or I could do what that guy's doing. With Albert, you never thought that way, and nobody ever could. He was one of a kind, and we all miss him. He was the best.
Is that? I mean, I would assume the cross-examination is probably, and maybe closing arguments, but probably more like cross is probably your favorite part of any given trial. Would that be a fair assessment?
Yeah, cross and closings are the best. I think opening is the most stressful, to be honest, because you don't have a feel yet, and you really have. I think openings are probably the most important. And luckily, my partner Margot and I, when we split trials, she usually does the opening. But I think openings are the most stressful.
It's funny because, again, I guess it's another difference between state and federal, right? The few federal cases that I've been involved in terms of litigation, there is virtually no jury selection permitted.
Correct.
Your judge will let you submit a couple of proposed questions. Maybe you get 10 minutes. In state court, depending upon the severity of the charge, you could have a half a day of voir dire. And so I clearly think jury selection is the absolute most important part of any state court trial. And so because of that, I think understanding how to pick a jury becomes more important than anything else, because your jury that's it. That's your end game right there.
Totally agree with you. And, it's sad that in federal court, we don't get a lot of jury selection. These judges that come over from state court where they gave voir dire come to federal court and say no more voir dire. I ask them, what happened? They said, we don't have to do it anymore. Apparently they don't like it, but I'm not sure why. I think you mentioned Stan Blake before. I think if Stan ever became a federal judge, he would let people do voir dire. He was a master.
Yeah, he loved watching voir dire, I think, as much as he loved presiding over cases. That was, it's really, I don't know. All components of trial have their pluses and minuses, but I just find that to be the really the most important and most interesting component. Not that there's anything less compelling than cross-examination or closing arguments or even opening statements, but getting that jury, and it's got to be very frustrating in federal court. I mean, you're going to be with these people for days, weeks, months, and you have no idea who they are.
It's wild. It's wild, and it's unfair. And it's, of course, just to help the conviction factor in federal court, because the less you know, the more it benefits the prosecutors, of course.
So speaking of conviction factors, I've always felt like you're the underdog as a defendant and a defense attorney, because you've got the weight of the government on top of you. And, I don't care if it's the state or the feds, they basically have an unlimited bankroll and unlimited resources if they wish to unleash them. They don't always, but they can. And I guess we talked about earlier in the show how most federal cases are the product of some degree, usually a very large degree, of investigative work before anybody's ever taken into custody. But even in state court, you find that those folks who are facing charges, they're up against what I would call the mammoth, or in your case, Goliath.
People do not realize what it's like to be charged with a crime, whether it's a minor crime in county court all the way up to the most serious in federal court. It's the fight of your life. And, even the former president of the United States is seeing that now as a criminal defendant. He was in court. There was an agreement as to a ROR bond, which you, by the way, rarely see in federal court. Okay, fine. Everybody agrees. The judge said, no, I'm going to issue another special condition, which is the defendant, former President Trump, cannot speak with any of the witnesses. Government, give me a witness list. And the government this week provided 87 names that Trump can't speak with. Now, this isn't a bond condition that they even asked for. So it's just every step of the way is a battle, and it's very, very difficult.
Well, that's a battle with the judge. But My question more focuses on battling with the government itself. So let's say the government had, dropped a laundry list of requests and conditions, which in fact they didn't in this case. I think they probably had their strategic reasons I mean, first of all, where's the guy going that they don't know who he is? Where could he possibly hide? There's nowhere. The man's name is written on the back of his freaking airplane. Where, I mean, how are you not going to know it's him? You don't have to look for a tail number.
Yeah.
But in this case, maybe the government made that calculation, right? And they said, look, we know a lot of people are going to be really angry that we're doing this. Right, wrong, or indifferent doesn't really matter to much of the population out there. So they probably did their own calculation. But that's clearly the exception to the rule, because most people that enter the criminal justice system are not treated that way by the United States Attorney's Office, certainly not at their initial appearance. If they're even welcome, if they're even given the opportunity to surrender and appear in court, which is almost never the case, right?
That's exactly right. So people who are, during this investigative stage, make it clear that they're going to fight, a lot of times get arrested for no reason. They've been in touch with the government.
Well, there is a reason. It's this.
Yeah, well, no legitimate reason, I should say. You're right. It's just to bully the person. And you even saw it with Aunt Becky in the cases out of Boston dealing with Varsity Blues. Like, they tried to arrest that actress for no reason. And so, if you cooperate, you can surrender, and if not, you have to get arrested. It drives me bananas.
Do you do cooperation cases, or do you have a hard line on that? I mean, some lawyers do and some lawyers don't. I don't know. Feel free to, tell me to pass on the question if you're not comfortable answering.
No, I'm happy to answer. So of course I do, because it's impossible to practice in federal court and not do it. Sometimes your clients, that's in their best interest, and they decide to do it. Most of my practice, thankfully, is not that. Most of my practice is not cooperating folks. And by the way, most federal criminal defense lawyers, that's what their practice is cooperation. That's the sort of classic federal case, right? But I do it a little bit, but not a lot, Michael.
I remember it's got to be close to 30 years ago, because it was early in my career. I went to a CLE that was a panel discussion. It was a federal judge from Broward. I can't remember who the judge was. And there was a U.S. attorney. And then the defense attorney that they had on the panel was Fred Haddad. And they're on this whole block talking about cooperation and snitches and this and that. And Fred's just sitting there like this the whole time.
Yeah.
Rolling his eyes. And ultimately it comes around to him and he doesn't say anything. He's dead silent. And everybody's looking at him. He just leans forward. He says, I have nothing to say here. I don't do cooperation.
I love it. He's great.
His practice, I don't know if that's the way it went, subsequent to that. I assume it was, but is an interesting guy.
He was like that. And another guy named Vinnie Flynn wouldn't do it either. There's some classic old timers who just would not flip their clients. I love it.
So I was doing a little bit of research on David Oscar Marcus, and I came across an interview that was done about 10 years ago. And they asked you some questions, and one of the questions they asked you was, you are often in trials for a long time. Do you have any daily rituals? And your answer was that you don't sleep and you watch A Few Good Men before every trial. Is that still the case?
It's still true. I don't sleep. I think I've memorized A Few Good Men, which I love. That you mentioned My Cousin Vinny, which is great. All those great old law movies, I think are wonderful inspiration before trials.
I have my own protocol before trial, or even aggravating evidentiary hearings. That doesn't involve any law movie, but it involves the soundtrack to Braveheart.
That's good.
I like to listen to that Celtic war music.
Hold the line.
So yeah, that kind of always gets me stirred up a little bit.
Love it.
So I know that you had Professor Dershowitz on your podcast. At least I saw him on your list, and I know he was one of your professors at Harvard. And I read somewhere that you had said how fortunate you were to have a relationship and be able to communicate with him. Open line of communication. So I was hoping you might put in a good word for me. Maybe he'll come on my show sometime.
Happy to do it. And he's a character and he's great. We're lucky, Michael, because we've had lots of great mentors. I know you have one that we share in common with Milton, who's awesome, and just had him on the podcast. You should have him too. He's just such a great storyteller and a great guy. So I think having a great mentor is really important in this field.
Would you say that Professor Dershowitz that was his role, or do you have other mentors that you know?
I've been very lucky. I've had lots of mentors. He's one, Milt's one. My dad, who passed away, who was a lawyer for over 50 years, was my most important mentor. At the PD's office, I was lucky to have Kathy Williams, who's now a judge, Mary Barzy as a mentor. Lots of folks over the years, so I'm lucky. The judge I clerked for, Edward Davis, was wonderful and a mentor. So I've been really lucky.
Former chief judge, no?
Former chief, that's right, former chief.
So I had to research that because I had missed your first job previously. You did a stint early on in your career in DC, correct?
I did. So after I clerked, I went to DC at Williams and Connolly, which had the greatest criminal defense lawyer of the 20th century, Edward Bennett Williams, as the leader before he passed away. Great firm, huge firm. But then I got an offer from the federal PDs down here, and I couldn't turn that down. So I jumped at that.
One of the reasons that I avoided federal work when I first started my practice, like anybody who would pay me, I would do what I had to do because, you're green, you don't have a whole lot of experience. You've never really practiced law before. It's tough to get people to have any confidence or faith in you. But back in that day, I was doing a lot of what was at that time called special appointed public defender work. And basically, it was an unregulated industry at the time. Now, of course, it's all structured. There's a state commission. You have to, put in applications. You have to be certified. Everything is scrutinized. But back then, judges were just appointing whoever they wanted to whatever they wanted right off the bench without any sort of a check valve. And it was very, as you can imagine, political and basically a thing that judges were doing as favors and courtesies to people that they liked, more or less. And of course, that practice has been phased out. But I had also applied at that time to get on the federal wheel because the federal system has the same type of overflow protocols where they don't have a public defender and they have to appoint a private lawyer. I forget what the name of the federal wheel is.
CJA, yeah.
CJA panel. And when I applied to get on the CJA panel, one of the things they told me was, if you ever decline a case, you're off.
Yeah.
And I said to myself, what does that mean? And they said, well, you're basically on call from, I guess, Fort Pierce to Key West. And whenever you get appointed to a case anywhere in the Southern District, you have to take it. And I'm like, what do you mean? You mean I have to go to Key West to try a case for 3 weeks? Or I'm off the wheel? They said, yeah. I said, do me a favor, shred my application.
Yeah, they changed it up. So now you can sign up for particular divisions. And now, in fact, they're pretty strict that you can only take cases in divisions adjacent to yours. So if you're in Miami, only Fort Lauderdale or whatever. And you can sign up for different lengths of cases. So if you only want, the short ones as opposed to the 5-weekers, you can sign up for those as well.
Well, that's good to know because, now there's at least some possibility that I might consider it. Although
yeah.
I just considered it and rejected it.
Okay.
Once again, I'll leave all those to you.
All right.
So, I guess we've covered virtually everything that I had on my notes.
Well, this was a lot of fun, Michael. I'm glad we finally did it, and I'm a big fan. I don't know how you do so many of these. You've done almost 70 now, which is it's amazing. It's amazing. Congratulations.
Thank you. I enjoy it. It's again, for the folks, if you have the chance to watch David's podcast, For the Defense podcast, this is a different level, I think. But mine is, and it's basically, I think, very illustrative of our practices, right? You do what we titled white collar work as a general rule, and I do what I call blue collar work. So this is a blue collar podcast.
Well, you're wearing a white collar today, so I don't know.
I did that on purpose. I was
Okay.
actually going to wear a T-shirt to really be demonstrative of the difference. But then I decided I have far too much respect for you to do that.
Hey, you have the tie on and I don't, so.
Well, it is almost Independence Day. I don't know if you can see that or not.
I love it. That's great. I love it.
So
I
as we're
love it.
up on the anniversary of our independence and the creation of what is the greatest experiment in countries in the history of our world, um, it's time for us to reflect on the Constitution and to be grateful for people like David who fight that fight because, guys like me who go up against local police officers and slug it out, yeah, we get credit too. But there's a lot more at stake when you represent people in serious federal court litigation. The cases that David handles. I'm sorry we didn't have enough time to get into any of the cases that I listed to talk about. But we could have gone on for hours, I'm sure. So maybe you'll come back and join us and talk about your private cases, some of your more personal views on some of your historical cases another time.
Would love that, Michael. Thanks so much for having me.
David, thank you for having me. Thank you all for joining us. We are not going to have a show next week. I understand that July 4th is on Tuesday, not Monday, but we're going to extend the Independence Day weekend an extra day. And in observance of that, we will be listening to the Ballad of the Americans, Ballad for America, and doing what we need to do to celebrate the anniversary of our country. Thank you all for paying attention, for chiming in today. David, thank you for joining us. And we look forward to seeing you on January 10th for episode number 70.
Thank
So
you,
long.
guys.